Luigi Mangione is back in court, but this time it's federal court. What's coming up next? May it please the audience. I'm Rich Schoenstein, and this is So Sue Me, the podcast about civil litigation. Well, usually about civil litigation, but sometimes also about big cases. And as you know, I'm covering this Luigi Mangione prosecution, which is happening in downtown New York in the state and federal court system. I've been in court to watch some of it. I'm paying close attention because it's fascinating to me for numerous issues. So tomorrow, Luigi Mangione has an appearance in federal court where there are a slew of motions brought by the defense that are going to be decided by the judge. They're probably not going to be decided tomorrow, to be clear, but there's going to be argument about them. And I want to sort of cover what's pending and what to expect. There are really three buckets of motions that have been made by the defense that are pending for the judge's decision, pretrial motions, and at center tomorrow and coming up next in this federal case is whether or not the death penalty is a potential punishment for a conviction of Luigi Mangione. And that, as you would understand, is a key issue. His defense team, his excellent, extremely well qualified, very capable, and very well-performing defense team, its front and center goal is to keep their client alive, right? This is a case where there seems to be potentially overwhelming proof. And I will say, Luigi Mangione is presumed innocent. He is innocent until proven guilty. But from what we've heard, there's a lot of evidence that he is the person who shot and killed Brian Thompson. Now, that has to be proven, and a jury has to convict him, but that's what we're led to believe. So a big question in this case for the defense has been, what will the punishment be if he's convicted? If you remember, this case has a prosecution in New York State Court and a prosecution in New York Federal Court. And for the most part, we've been focused on the state court proceedings. So two things happened last year in the state court proceedings. One, the defense managed to get the terrorism charges thrown out. In the state court proceeding, prosecutors had charged Luigi Mangione with murder, but they had also charged him basically with terrorism to set up a possible punishment of life imprisonment without the opportunity of parole. There is no death penalty in New York State. The top punishment is life imprisonment without opportunity of parole, but you only get that for first-degree murder. And first-degree murder has to be something more than intentional killing. Intentional killing of a police officer is first-degree murder, or there are several other different ways you get there. One of them was if it was part of terrorism. And so the prosecutors alleged that Luigi Mangione killed Brian Thompson as a terrorist act, and the court rejected that, threw out those charges. So in the New York State case, the top possible charge now is second-degree murder, and the punishment for that is life in prison, but with the opportunity for parole, an opportunity that Luigi Mangione, even if convicted, would be freed someday. That was a huge win in the state system. And the other thing that happened in the state system is this extensive pretrial evidentiary hearing where they went over the arrest of Luigi Mangione, his statements to officers, the interviews, their search of the backpack, both at the McDonald's where he was arrested and then subsequently at the police station. And the defense has argued that his statements to police officers are not admissible because he was not properly Mirandized. And the evidence found in his backpack, including, importantly, a gun, a silencer, a magazine, are not admissible because that search violated his constitutional rights. There's no decision on that yet. There's going to be post-hearing briefing over the next couple of months, and the judge has said there will be a decision sometime in May. And that is what's happening in the state court case. Now, in the federal court case, Luigi Mangione is charged with 2 counts of murder, and those charges have a possibility of the death penalty. And now you don't just get the death penalty for intentional murder, even in the federal system. You need more. The statutes say if there is a murder committed with a firearm in the course of committing a crime of violence, there can be the death penalty. So the federal prosecutors have alleged that the crime of violence is stalking, that Luigi Mangione stalked Brian Thompson both in person and over the internet, and that that was an underlying crime of violence, and that because he was doing that and killed Thompson with a firearm, he can get the death penalty. Okay, so Mangione's lawyers have brought a couple of different motions. The first motion they brought, and this they filed back in September, was a motion challenging the constitutionality of the death penalty. And this is sort of an overall attack on the death penalty itself. Now, the death penalty is constitutional, and there's no way this Supreme Court, in its current construct, is going to overrule that and decide that the death penalty is cruel and unusual punishment and should be outlawed, even though there are those that think that's the case. This Supreme Court's never going to do that. But what Mangione's team is saying is that the death penalty is being improperly invoked in this case. It's arbitrary and capricious to impose the death penalty on Mangione when they don't do it in other murder cases. They're also arguing that the process here was improper, that the government has made too many public statements about Mangione's guilt. And specifically, they talk a lot about Pam Bondi and things she said on social media and in interviews about Mangione's guilt, rather than affirming that he has the presumption of innocence until guilt is proven. It also talks about that perp walk. If you remember when Mangione was brought to New York, they took him off the helicopter. They had a big scene with a bunch of police officers dressed in riot gear, and the mayor was there, and it was a big television drama. And the defense says that poisoned the well. That poisoned the potential jury pool, who now assume he is guilty based on what they've seen on TV and based on what these government officials like Pam Bondi have been saying publicly for months, that Mangione can't get a fair hearing. The death penalty is not being applied in a constitutional way. It's arbitrary. It's capricious. They argue that it's improper to have a death penalty qualified jury serve in both phases of the trial, the guilt phase and the punishment phase, because a death penalty qualified jury, and that just means picking a jury that has people who say they're willing to impose the death penalty if the circumstances are appropriate. Some people will say they'll never impose the death penalty, and they're not allowed on that kind of jury. And the defense argues that a death penalty qualified jury is much more likely to convict. So there are all of these constitutional arguments pending in this motion. I anticipate those are all going to fail. They're well stated, they're well argued, they're well researched, and there are some underpinnings that I think ring true. But those kind of arguments have been made repeatedly in different cases over the years in the federal system, and they largely are unsuccessful. The general attacks on the constitutionality of the death penalty, I don't think are going to succeed. So let's move to the next motion. In October, the defense filed a separate motion, and this motion is to dismiss counts 3 and 4 of the indictment and to suppress evidence in the case, both the statements by Mangione to police and the contents of the backpack. So I want to talk about counts 3 and 4. Counts 3 and 4 are the murder charges. Generally speaking, those murder charges charge Mangione with committing murder using a deadly weapon, a gun, while in the course of a crime of violence. And it's that crime of violence hook or underpinning that gets you to a crime that is death penalty eligible. And the crime of violence alleged by the prosecutors in this case is stalking. There are 2 counts of stalking, the first and second count in the indictment. One is stalking basically in person, the idea that Mangione was following Brian Thompson, and the other is cyber stalking, the idea that he tracked Brian Thompson's whereabouts on the computer, on the internet, and stalked him. And the prosecution argues that stalking is a crime of violence and that Mangione killed Brian Thompson in the course of stalking him using a deadly weapon, and that gets you to the death penalty. And the defense says, in essence, stalking's not a crime of violence. Stalking can be violent, but it's not necessarily violent. It is stalking. And therefore, they argue, it is not a proper underpinning of the other charges that get you to the death penalty. And that is where I think the court is going to have some interest. If the defense is going to be successful, that's where I think it's going to be. Now, we know the court is interested in this argument because the court issued an order in advance of the conference for January 9th. The court wants both parties to be prepared for oral argument and to answer the court's questions regarding the defendant's motion to dismiss counts 3 and 4. The court will allot 30 minutes each to the government and the defense for this argument. As of the date of this order, given the extensive and excellent briefing by both sides on the other pending motions and issues presented by those motions, the court does not believe that oral argument on the remaining motions is necessary or would be helpful to the court. And then you see in this order that the court wanted some clarification as to what, if any, statements by Mangione, the prosecution, still intended to enter into evidence. So that's a federal judge doing a good job of setting up a hearing. The federal judge says, I've read your papers, I have your arguments, I understand them. I'm going to focus on this argument about count 3 and count 4, and I want to hear oral argument on those issues. That's really going to be the part of this hearing tomorrow that's going to be the most interesting, is the argument on whether or not counts 3 and 4 can withstand scrutiny, whether the stalking charges get you to a predicate crime of violence such that the death penalty can be invoked. If the defense can get the death penalty thrown out of the federal case, it's a huge win. It's a huge win. If they've taken life imprisonment without the chance of parole off the table in the state case, and they can take the death penalty off the table in the federal case, then they have guaranteed keeping their client alive and probably guaranteed an opportunity for him to be free sometime in his life, even if he is convicted. And that obviously would be huge. That's the number one goal of the defense. Okay. The other thing pending tomorrow are the same evidentiary issues that we just saw debated in the state case. Not really debated. We just saw a 3-week evidentiary hearing in the state case where the judge basically went minute by minute over the arrest of Luigi Mangione and the search of his backpack and what evidence was found. And in the state case, we're going to get a decision in May. That motion was also made in the federal case. It has to be made separately. It's a separate case and a separate judge. And the defense argued that the statements of Luigi Mangione shouldn't be allowed and the contents of the backpack should be excluded. So there's been a development in terms of the suppression part of these motions. The parties filed a joint letter on January 6th at the court's request, and they say that as to the motion to suppress statement, the government now is only seeking to admit Mr. Mangione's December 9th, 2024 statements to law enforcement, providing his name as Mark and Mark Rosario. And defense counsel hereby withdraws Mr. Mangione's motion to suppress his statement. So whatever else Mangione said to police officers at the time of his arrest, the prosecution isn't using. They only want to use the fact that he gave a false identification, allegedly. And the defense says, as to that, we withdraw a motion. That's okay. The prosecution can put that into evidence. In effect, that's a win by the defense. They got the prosecution to withdraw the potential use of any other statements that Mangione made to law enforcement. That's because Miranda was delivered at least 20 minutes after the police began questioning Mangione. That was too late. That created problems. That probably made a lot of those statements inadmissible, and the prosecutors have backed off. Now, the debate is still alive as to the contents of Mr. Mangione's backpack. The defense still seeks to exclude the contents of the backpack, and the defense argues in its letter that either you have to exclude the contents of the backpack or you have to permit an evidentiary hearing so we can explore this issue in more detail. And the prosecution says, no, you don't have to do that, Judge. You can simply deny the motion and allow the contents of the backpack into evidence. Just quickly on the contents of the backpack, in the federal case, what is being argued is the defense is saying it wasn't a lawful search and seizure, and therefore you can't put any of the contents into evidence. The government is arguing that it was a legal search of the backpack incident to arrest, and even if it wasn't, it is okay because the items in the backpack would have inevitably been discovered during an inventory of the backpack. Even if we didn't search it at the McDonald's, once we arrested Mangione and brought him to the police station, his backpack would have been inventoried. That would have involved a search. They would have uncovered whatever is in it. So any constitutional violation by searching the backpack without a warrant initially is harmless, in essence, because we would have gotten it anyway. The defense says, no, not so fast. Number one, you wouldn't have necessarily had to inventory the backpack. And number two, you haven't established that the inventory process followed appropriate police procedures, which is part of the test. And if you can't establish that, then you can't use the justification of an inventory. You can't use this inevitability concept, and you have to revert back to the question of whether the initial search of the backpack was legal, and it wasn't because there wasn't a warrant. So we'll see how that plays out. I don't know if the judge is going to want to have a federal court evidentiary hearing. We could see another evidentiary hearing with all of those witnesses back in a different court. Or maybe the judge is just going to deny it and say, I've heard enough to know that inevitably they would have located these items, and we've really resolved the issue of Mr. Mangione's statements, so we don't need an evidentiary hearing on that. Those arguments about the evidence in the federal case, I think, are a little less important just because of how important this death penalty issue is. The possibility that the defense could get the death penalty thrown out of this case is huge. That could really turn the prosecution of this case. And I think it presents a lot of very interesting issues. This case is loaded with interesting constitutional issues, interesting evidentiary issues, all sorts of interesting legal issues that really get my attention. Maybe initially I was put off because some of the Mangione supporters seem to take the position, yes, we think he did it, and we think shooting a guy in the back on Fifth Avenue is a good thing because that guy worked for an insurance company and insurance companies are bad. And I don't have a lot of sympathy for that position. I don't like that position. I don't think violence is the answer. I understand your problem with insurance companies. And a very smart and capable guy like Luigi Mangione had 100 different ways he could have advocated against insurance companies, or he could have gone into politics, or he could have tried to affect change. Shooting a guy on Fifth Avenue accomplished nothing. I don't know about you, but my insurance premiums shot up again this year. So the idea that something was accomplished by picking a guy and killing him seems ridiculous to me. And I didn't like that, and I don't like that idea in his defense. But Luigi Mangione is presumed innocent. That's the way we do it in America. He is innocent until proven guilty. He is entitled to his constitutional rights. He is entitled to have these issues vetted by the court. Was his interview legal? Was the search of his backpack legal? Is the death penalty being properly invoked? Was terrorism being properly invoked in the state court? All of those are fair grounds for legal argument. His defense team is pushing on all of them, and I think doing a brilliant job, regardless of what the outcome may be. and I think he has every right to push those issues. So I'm locked in, very interested in where this case is going. We're going to keep track of it here on So Sue Me. We're also going to talk about civil litigation, which is what I promised to talk about. We're going to watch this Mangione case and probably some other interesting ones again. Don't forget to like and subscribe and do all that nonsense. We will see you soon. Happy New Year. For now, we are adjourned.